Okay, Mike, as I told you, based on the evidence I see in the law and the case law, it is my understanding, Part 369 in the FMCSA regulations dealing with safety inspections, that the officer in the scale house does not need probable cause to do safety inspections when you pull into the scale house. But an officer on the highways and byways cannot just randomly pull someone over under the guise of a safety inspection without a justification, which would include probable cause or reasonable suspicion for a needed safety inspection. Yeah, I mistyped. So it responds under 49 CFR 396.9. Officers at scale houses do not need probable cause to conduct safety inspections of commercial vehicles. Now, why would that be? Part of the reason why is when you filled out paperwork to be able to operate in commerce, you signed agreements that says you will do this in the scale house voluntarily. Okay. So there are contracts in place. A lot of those contracts the government puts out are adhesion contracts, by the way. So you're right that in a scale house, they don't need probable cause. And the video I was talking about had nothing to do with a scale house. This regulation authorizes FMCSA certified officers to perform inspections of vehicles in operation and intermodal equipment without requiring suspicion or probable cause. However, the situation differs for officers on highways and byways, where random stops for safety inspections without justification are generally not permitted. Why is that? One, look up Part 6 and Part 7 of the Hobbs Act. They, one of those parts deals with, I think it might be Part 6, but don't quote me on that, interference of interstate commerce. If there is no justifiable reason, they cannot just do it. That would be considered an interference of interstate commerce. So I'm in agreement with you when you're talking about scale houses, but not on highways. For inspections conducted on highways and byways, the legal standards differ. Courts have generally required some level of justification, such as probable cause or reasonable suspicion for random stops outside of the designated areas. In United States versus Chandel, the court emphasized that the regulatory scheme for inspections was limited to ports of entry and did not authorize warrantless roadside inspections by roving patrols. Similarly, in State v. McClure, the court noted that while inspections at designated stations or safe roadside locations were permissible, random stops without justification were not. Okay, so when I say the things I say, Mike, it's because I've studied it. I'm not saying when it comes to the scale house part, you are 100% spot on. They do not need probable cause. But on the highways and byways, if you are doing your pre trips and you are keeping that vehicle in safe working order, that can be seen just by a cursory glance. There is nothing out of whack. Now, if you blow a tire and you're unaware of that tire being blown, that would be enough for probable cause or a justification for them to do a safety inspection if they saw it and you were not observant and doing your job properly. So, take this for what it is, Mike. This is what the courts have stated.